today as well from the European IP Helpdesk. My name is Michele Dubini and I'm part of the European IP Helpdesk training team. And today is for me a pleasure to welcome you all, of course, like in the other events that we have organized in the first and second half of the year, but particularly as opposed to other webinars we've got very special guests with us today, Catherine Unholz and Tjeerd Overdiek, who are going then to introduce us to a very particular topic which regards plant varieties and enforcement. For protection of rights and enforcement of rights. It's the first time that we are together, and I am very eager to know more about this topic, of which I have to admit I am a little bit ignorant, and therefore this is a great occasion to us to dig inside this topic and learn a lot with regard to this particular sphere of intellectual property rights. Before we start, however, with the actual content, as somebody of you perhaps already know, you've been together with us in the previous webinar this year or the previous year, I will introduce you to the tool that we are using today, which is GoToWebinar, and to the services of the European IP Helpdesk. You might have asked yourself why you are muted, and that is why we expect to have around 50 participants, and also the slightest background noise could be harmful for the webinar and could prevent our speakers from sharing information with us. Therefore, you are muted, and you will be muted throughout the whole webinar, but that does not mean that you're not allowed to ask questions. You're actually welcome, very welcome to do so. You can do it at any moment, simply writing that in the question part of the screen that you can find in the small menu that GoToWebinar has provided to you, and I will gather all the questions throughout the presentation. And also we will have afterwards a question and answer part where I will then read all the questions loud, and you will be able to see them on a Word file as well, and we will go through them, try to answer, of course, the best we can. Additionally, you will receive today's slides and recording. That is going to happen at the latest tomorrow morning. I will make sure that the presentation is cut and sent to you, and also you will receive a PDF PDF format of the presentation that has been carried out today. That's so much for the GoToWebinar settings. Just let me introduce you very quickly to the European IP Helpdesk services. We are a service initiative of the European Commission that has the objective of addressing, let's say, current potential beneficiaries of EU-funded projects, researchers, small and medium enterprises across the European Union. Just to name some of them, those are our main target. However, the services that you can see on the right-hand side of the screen are open to everyone, are open to each and every user that might be interested independently, if they are small and medium enterprises or researchers. So they are open up to everyone, and they are also free of charge. The website, which you can see on the right hand corner, up corner of the screen, you see ec.europa.eu/IP-helpdesk, is the entry door to the all services that we offer, meaning trainings, helpline service, available publications online where you can learn and study regarding intellectual property rights, and also download templates for your use. We also have an ambassador network, which might be in the vicinity of your premises. And we also share our space in the website with our siblings from Latin America, China, Southeast Asia, India, and from the 21st of October of this year, also the Africa PSMA Helpdesk. So they offer the very same services that we offer, that you can see on the right-hand side, which I will explain a little bit more in detail in the next few slides, but with a different geographical area. So if you're interested in different geographical areas which are outside Europe, they are your sparring partner to share information. I would like to draw your attention on a very important service that we offer, which is the helpline. The helpline is a free of charge first line IP support, meaning that they will receive your question and answer them. On a free of charge manner, meaning that they're not going to charge any form of payment for the service that they offer. But at the same time, they are not patent attorneys, meaning that you cannot pretend or ask them to write down the claims, for example, of your patents, or to set up a sue case against somebody else, but they will advise you about what you can do next with intellectual property that you might have in your hand. And the advantage is that they answer to your questions, so the service is personal and directed to the point. And the answer is quick, meaning that it's going to be dealt within 3 working days. You can contact them via email, phone, or also through our website. The answers or the questions should be in English preferably, but it can also be in
Michaela, I'm not sure whether you can hear us. Your connection is very bad, so your image and your sound is interrupted.
Which is suggestion, please just write them in English. It's going to be easier to find one expert.
You're muted again.
Yeah.
I'm afraid. Okay, it's not working. Maybe you can switch off your camera and we can still hear you, probably.
Michaela, we cannot hear you. I'm afraid we cannot start our part of the presentations, as Michaela has to change the moderator's mode. So we will just need to have a little bit of patience. Michaela, we cannot hear you.
Maybe you can switch to Katrien. Terrible.
Michaela, can you change the moderator's mode and put it over to me? He's reconnecting. We hope that we are more lucky during our presentation.
Yeah, exactly.
We're very sorry, but we cannot do anything.
We can also not change the presenter from our end.
No, I don't think so. Let's try. Yeah. No, unfortunately, possible.
The attendees are still there and seems to increase even the number. If we
Okay, now I could start with a short presentation of CIOPORA. I think I should do that in the meantime, so we can go ahead a little bit. I can now share my screen with you. I hope that works. Chad, can you give me feedback whether you can see my screen?
Yes.
Yes, it's working. My apologies. I could come back. So
okay, yeah. Should I then do CIOPORA, or do you want to come back and finish?
No, go on. I think I was going to give you the word anyway. So I explained a little bit the helpline, and that's fine for me. Go on.
Oh, okay, thank you very much. So what I want to do is give a very short introduction into CIOPORA for those who don't know our association. But before I do that, many thanks to the team of the IP Helpdesk for giving us this opportunity to cooperate with you and to train professionals in IP for plants. So many thanks for teaming up with CIOPORA. So CIOPORA is the international community of breeders of asexually reproduced horticultural varieties. That means that we represent breeders of fruit varieties and ornamental varieties and also medical cannabis. This is all included in the horticultural varieties. We exist since 60 years this year. We were founded in 1961, simultaneously with the establishment of UPOV, the International Union for the Protection of New Varieties of Plants. And today we have 133 member companies all over the world. We have breeding companies, IP lawyers, title holders, and associations are our members. And we represent not only these members, but I think that there are more than 200 breeding companies, small and medium-sized breeding companies that have a positive effect of our work. At our office in Hamburg, we are 6 people working there full-time and half-time, and all with international background. And the 5 pillars we build our activities on are representing and promoting the interests of our plant breeders before governments, like, for example, in China and in the United States, and obviously also in front of the EU Commission. IP advocacy is including strengthening the systems of IP protection worldwide, and we also monitor the global developments also in, for example, in biotechnology. Communication is one of our high priorities, not only members-only communications, which would be our public, which would be our episode newsletter, or for example, enforcement toolkits about specific countries. But we also have a public newsletter called IP Chapters, and you're more than welcome to subscribe to it on our website. Last but not least, the CIOPORA Academy, which is the international education program for all professionals in the horticultural sector. And I'm responsible for the CIOPORA Academy. Today, I'm replacing my colleague Anna Kene. She's the Director of PR and Communications, and she's traveling together with 2 other colleagues to the first trade fair since 2 years, I think, to the IFTF in Amsterdam. So that's why I'm sitting here today and talking about CIOPORA. So CIOPORA Academy was started in 2015, and we have held since then 12 workshops in different locations around the world. We have now had 24 webinars also due to COVID. Otherwise, we would prefer the workshops, but it's a very good tool to reach many people around the world and educate about IP for plants. The little sister or brother of the CIOPORA Academy is the CIOPORA Breeding Academy. And this month we will still have 2 webinars addressed to breeders and R&D departments of the breeding companies. And these 2 webinars will deal with the consequences of climate change for breeding. And on the other hand, we focus on biotechnological approaches of our asexually crops. One of the tools is tissue culture techniques. So if you would like to receive more information about the CIOPORA Academy, please go to our website, cioporaacademy.org, and you can also subscribe to updates there. The next slide shows our partners, our other associations with whom we cooperate. We have Euroseeds and ISF and CropLife, who are focusing on seed plants, and more associations on the left side, IPH, Union Fleur, Expo Flores, and many others. On the right hand side, you can see many governmental bodies we have constant contact with and exchange information. UPOV, CPVO, of course, and the Chinese Ministry of Agriculture and Ministry of, what's the name? Forestry and Grassland Administration, sorry. And also in the United States, we have the US Department of Agriculture and US Plant and Trademark Office. If you would like to learn more about plant breeders' rights, please go to this link after having received the presentation. This is a very comprehensive magazine that we have published this year on the occasion of the anniversaries of UPOV and CIOPORA, and the special magazine is a journey towards the beginnings of UPOV as well as the future. So this was the short introduction of CIOPORA, and I imagine that you're now waiting for Tjeerd Overdijk to start his presentation. I would like to introduce him to you. Tjeerd Overdijk from the Netherlands. He has studied law at the University of Leiden in the Netherlands and has been a lawyer since 1984. So more than 25 years as an all-rounder in the field of intellectual property, and he's one of the few specialists in plant variety rights. For example, he was involved in the first court case in the world on the concept of essentially derived varieties, EDVs, which is still a very discussed topic. And he has also experience with litigation before the Board of Appeal of the Community Plant Variety Office in Angers. Tjeerd also teaches in postgraduate programs on his field of expertise, and his law firm Fonst Advocaten is a very long time member of CIOPORA. And currently, he is the chair of the Lawyers Panel, a legal expert group within our association. Tjeerd is an excellent speaker, and he has proven that a lot of times at the CIOPORA Academy workshops and webinars. And I would now like to hand over the microphone to you, and I wish everybody a good learning session. Thank you.
Thank you very much, Katrien, for your kind introduction. I hope I can show the same excellence in a webinar setting. Now I have to share my screen, of course. Let me check. I should bring the presentation on screen. So this should be it. If all is well, you are getting the presentation on screen perfect. Now. Is it perfect? Okay. So enforcement practices for PVRs in the EU, that's what the webinar is about. And this is what I would like to tackle with you today. Before I head off with enforcement regimes and enforcement practices, I think I need to give you a little very short introduction on what means IP right, certainly for those who are not lawyers. Then I'm going into enforcement regimes, into conservatory and provisional measures, sometimes very important to act quickly. Another important topic is compensation of damages and related claims. And if we have time, we can also touch on some territoriality and cross-border aspects. But first, what means IP right? Most of you will know it, but for those who don't, the idea behind intellectual property rights is that the making of innovations and creativity should be promoted. With the making of innovations, we are obviously talking about patents and new plant varieties and sometimes new designs. And when we are talking about creativity, we are more looking at copyright works, but these are all products of innovative and creative activity. Well, basically all legislators and the majority of people in the world think that that sort of activity helps to make the world better, that it should be promoted, and that there should also be protection for the results of those activities in order to enable the innovators and creators to earn on their investment and on this activity. And this is why the creator, the maker, the author, the inventor, and also the holder of a trademark needs to get a monopoly. It is a limited monopoly for us, usually for a certain period of time. And with this monopoly, he can earn back his investments and obtain a reasonable remuneration for his activity. That is what IP rights is all about. And the monopoly is always in all IP acts. So that is true for patents, for plant variety rights, for design rights, for copyrights. It is described in the form of a list of exclusive or restricted acts. So patent law and copyright law and plant variety law always include a list of acts which may only be undertaken by the IPR holder or with the permission of the IPR holder. So let's assume you have been granted, you have created and developed new rose varieties, and you have been granted a number of plant variety rights, and with on the basis of these rights, this is the more or less standard list of excluded acts for plant variety rights. That is, in the first place, you are the only one who may produce or reproduce the plant variety. You are the only one who may condition it for the purpose of propagation. You are the only one who may offer it for sale, to sell or market the variety, to export it from the community or import it into the community, and lastly, to stock it for any of the purposes that I already mentioned. So as the holder of the right, you have the choice to do it yourself or to authorize others to do it. And that's when you enter into license agreement, where you can agree with someone else to enable him to undertake all of these activities or part of these activities, depending on what you agree on. Now, this is a right, of course, which, if you encounter competitors who are propagating your variety or importing your variety from elsewhere without your permission, you must do something against it. And that is what we call enforcing your right. And this is basically dealt with in all sorts of laws, and we have laws at various levels, and this is a list which you see on screen of where you can find the rules on enforcing plant variety rights. In the first place, we have the CIOPORA Convention, the international, basically UN convention, which specifies what the right is all about in Articles 13 and 14. We have at EU level, we have the Community Plant Variety Regulation with this funny abbreviation on screen. And there are rules about enforcing plant varieties in Articles 94 through 107. Then there is a EU regulation which deals with the combat of piracy, which is a bit of a special subject in relation to plant varieties, but I hope to have the opportunity to tell you a little bit about it. Then we have another important set of EU rules which is already in existence since 2004. That is the Enforcement Directive. And then, of course, at the national level, there are all sorts of national legislations concerning PVRs. Every country that is a member of CIOPORA has that kind of rules. And there are also national procedural rules which are dealing with all sorts of IP rights, including plant variety rights. If we look a bit closer to the enforcement rules in the EU regulation, that's this range of Articles 94 through 107. Article 94 deals with the getting of an injunction and compensation of damages. An injunction is obviously when a judge tells someone that he should stop undertaking certain activities which are infringing the right, basically. So the whole span of enforcement is basically that there is a rule which says that the right holder is the only one who is authorized to undertake a certain activity, such as importing or propagating. And if someone does not abide by these rules, we need a judge who says, you may not do this any longer, you have to stop this, you have to pay damages. And then obviously the third pillar is that if the subject who has been condemned to stop or to pay damages doesn't do so, you must have means to make him do so, and that is usually where you need a bailiff to, or sometimes even the police, to exercise force and make sure that there is enough incentive to abide by the judge, by the order of the court. That is all about that's usually how I explain the word injunction. Then we have in Article 95 a special form of protection called provisional protection for rights that have been applied for but not yet granted. There is an Article 97. I'm simply listing now the most important articles. 97, which deals with surrender of profits. So if an infringer makes profit, this article forms the basis to make the infringer turn over these profits to the right holder. And then we have Articles 103, 104, and 107, which deal with procedural aspects, with enforcement by licensees, and there is also a provision regarding criminal sanctions. I must say I'm from a country where criminal sanctions for IP rights are not applied on a wide basis. It's rather exceptional that an IP infringer has to appear before court here. There are other countries where, like France and Spain, where the criminal route the criminal courts are much more important and play an important role in enforcing IP rights, but that's not the case in every country. But this Article 107 forms the basis in relation to EU rights. Then, as I mentioned, there is an EU directive already since 2000 which has the objective to harmonize the laws and to make life better for right holders and to make it easier for them to enforce their rights. And in order to accomplish that, the EU issued this EC at that time, the European Commission, and the Parliament, of course, issued this directive in order to guide and direct all member states to improve their laws in several respects, and a list of that is on this screen. So the directive says that the member states should enable their judicial authorities to order the submission and disclosure of evidence. The national laws should grant right holders measures to secure evidence. I will get to that in more detail in a minute. The national laws should also secure a right to information on the extent of infringements. So you should be able to get names of suppliers and numbers and information on sales prices and profits received, etc. The rights holders should get appropriate possibilities to undertake provisional measures and protective measures. The laws should also provide for corrective measures, such as the removal and destruction of infringing material. It should be possible to get an order to cease and desist infringement. That's quite obvious. And there should be better provisions regarding damages. And lastly, and also quite importantly, there should be better and more favorable rules for rights holders in regard to the recovery of legal costs. I will get to that too. This is a list. I will skip that. Of course, this is an EU seminar, and I'm from the Netherlands, so I'm talking for a large part on the basis of my experience in a national environment. But sometimes we also have cross-border situations where we have to combat infringement in a number of jurisdictions, and sometimes these cases also reach the European Court. But I'm going to skip the list, which is similar to the EU list in the interest of time. I will now take you to the European Basic Regulation, as we also call it. A very important provision in that regulation is the definition of what are infringing activities, and there are three categories. In the first place, it says that infringing is when someone commits acts set out in Article 13, paragraph 2, without being entitled to do so. So, an Article 13, paragraph 2 is the provision in the regulation which basically says, lists the excluded activities. So if someone undertakes these activities without being entitled to do so, without having a license from the right holder, this is considered infringing. The second form of infringement is when someone omits to use correctly a variety denomination. As you may know, every plant variety must have its own denomination under which it has to be traded. And if you do not use the correct variety denomination, this is also a form of infringement. This is what follows from this Article 94. And a third form of infringement is when there is a use of a variety denomination, but it is not correct, or it is a denomination which may be confused with a denomination which is already existing. So these are the forms of infringement listed in Article 94. Article 94 also refers to damages, and therefore we need to look into a little bit into the definition of damages, and usually that is fairly standard across all countries in Europe, at least, is that damages consist of all costs and expenses incurred, which can include costs for the prevention or mitigation of damages. So if you need to undertake some research, you need to involve investigators in order to find infringements, that kind of costs can be compensated. And also costs connected with determining the amount of damages suffered, like the costs of involving external accountants, and extrajudicial costs to obtain compensation. With an extrajudicial cost is typically the costs which you incur when you ask a lawyer to write a letter. So not already moving to court action, but simply writing a letter to someone else, a demand letter, which explains that your client has certain rights, and that it has come to the attention of your client that you are undertaking activities without his permission, and that is an infringement. That is all at the extrajudicial level. So that is costs which should also be compensated. And then a big factor, a big element in relation to damages is of course lost profits. So if there is an infringement, if there is an infringer who sells a lot of plants of your variety without your permission, that usually means that you are selling less plants and that you lose out on your ability to make profit with the right. There must be a loss. Why am I saying this? I always refer to a quite old case. What am I doing now? Well, it should be moved back. So that is the case which came before the Netherlands Supreme Court in 2002. In this case, the defendant, Oldenburger, had propagated 20,000 rose plants without a license from the right holder, and the right holder was Interplant. And somehow Interplant had been alerted in time and had written a cease and desist letter to the infringer, who then immediately decided to uproot the 20,000 plants. And in the court case that followed, Oldenburger, the defendant, stated there is no damage because the plants have not been brought into circulation. And in reaction to that, Interplant claimed that they could have asked compensation because this was a case of illegal propagation, and propagation is one of the excluded acts, as you have seen. And therefore, they said, you should have asked my permission, and if you would have done so, I could have asked you for a compensation. Interplant was, the claims of Interplant were denied in 2 instances, and they finally came before the Supreme Court. And the Supreme Court ruled that for determining the amount of a compensation due to an infringement, a comparison should be made of the situation in which the injured party finds itself as a result of the infringement, And you have to compare that with the situation where the infringement would not have occurred. And in this case, if the plants had been uprooted and had not been brought into circulation, there was not there was basically no prejudice. And the Supreme Court added to that, if you see the customary compensation for oculating, for propagation as damage, this is only part of the story, because the consent that is usually asked from the right holder by a grower would have included the consent to market the plants which have been propagated on the basis of that consent. So in this case, there was no allocation and no application of abstract compensation of damages. You must have a real loss, and if there is no loss, there is no right for compensation. I always think that is as a very unjust result, because there have been extrajudicial costs. They had to write a letter. It results in a necessity to do all kinds of handling. There has been an illegal act, but well, there is this rule confirmed by the Supreme Court that there has to be a real damage. Then I'm turning back to Article 94, which I already mentioned. Article 94 has two paragraphs. The first paragraph says that if there is an infringement, that then the infringer may be sued by the holder and may be held to pay a reasonable, then the holder of the right can ask the infringer to enjoin such infringement, so he has to stop with it, or to pay a reasonable compensation for the infringement, or both. So that's the basis to ask damages in the form of a reasonable compensation, and that is that applies to every kind of infringement, also the unintentional infringement by someone who was not aware of the fact that a plant variety was protected. Then there is a second form of compensation, and that is for in cases where someone acted intentionally or negligently, and in those cases the right holder shall be able to claim any further damage resulting from the infringing act. And in cases of such, and this provision adds that in cases of slight negligence, such claims may be reduced according to the degree of such slight negligence. So in infringement cases, you are always discussing about the question, was this an unintentional infringement which occurred as a result of a person not being aware of the right or the protection, or was this a willful and intentional infringement? And then you come, then the holder qualifies for further damages, and we will get to deal with that in a bit more detail. Another important rule is Article 97, which says that where the party who has committed an infringement pursuant to Article 94 has made a gain at the expense of the holder or of a person entitled to exploitation rights, person entitled to exploitation rights is typically a licensee, that for that kind of damage element, so regarding the gain, that the national courts should apply their national law as regards the restitution, as it's called, of that gain. And at this point, I should probably explain a bit more about the distinction between compensation of damages or the surrender of profit. Sometimes it's very problematic to assess your damage, because if an infringer sells plants, infringing plants of a variety for an amount much less, you always have a discussion whether the right holder would have, or his licensee would have, sold the same amount of plants if they would have been much more expensive. So you can hardly ever state that an infringement should entitle the holder to the regular royalty for the same number of plants which the infringer has sold. And this is an element, and that is why many laws, and also European law, provide for an optional right to the holder. So that if the holder, if it's difficult or problematic to prove the amount of damages, you can also resort to an alternative, and that is ask the infringer or ask the court to order the infringer to basically surrender the profit he has made, and then at least, maybe then you have no damages, but then at least you have the profits. As a holder, you can get the profits made as a result of the infringement. And this is what Article 97 refers to. Let me check. Yeah, maybe I should skip this also, because this is a bit complicated. I would like to take you to this case, which gives you also a good picture of how damages are being dealt with. This was the case HECO against SPEC, which is a nice example of how Article 94, paragraph 1 is being applied. In this case, the company, the defendant HECO, had produced 100,000 cuttings without a license and had delivered them to a third party. He had obtained these cuttings by purchasing unrooted cuttings and propagating them to rooted cuttings, and he had sold the rooted cuttings for 19 cents per cutting. He had bought the unrooted cuttings. You must pay attention because there's going to be a question about this. So he had bought the unrooted cuttings for 3 cents. He had propagated them to rooted cuttings, and he had sold the rooted cuttings for 19 cents. And these were all infringing because he had done this act of propagation without a license, and the right holder, SPEC, claimed that he had done so without permission, and that SPEC had suffered damage as a result of these acts. And for a regular licensee, there were always license agreements, and according to the license agreement, a regular licensee should pay 30 cents per plants. Now, I thought, in order not to be the one who is speaking all the time, I have a quick poll, and now I'm asking Michele to also bring the poll. So, what do you think in a case like this? What was the amount of damage compensation which the infringer had to pay for plant per plant? So it was 100,000 plants, and you can select one of the following. Was he ordered to pay out his gross profit of 19 cents minus 3 cents? Was he ordered to pay his net profit, because he could also deduct 6 cents of production costs? Production should be production. Or was the infringer HECO ordered to pay an amount equal to the regular royalty of 30 cents per plant? Now the poll is in progress, which gives me the opportunity to take a sip of water. So
we currently have 48% of participants who have answered, and 23% answered A, gross profit, 23% answered B, net profit, and 54% answered C, equal to the regular royalty of 30 cents per plan.
Okay, very interesting.
To show the results.
Yeah.
Well, the majority.
Yeah, this is fine. This is great. You have all listened very well. Although I didn't really explain a lot, but the majority is right, and the two minorities are not right. The court in this case said that Article 94 of the regulation calls for an autonomous interpretation. There is no other requirement that there is an infringement of the right. Of course, HECO, the infringer, argued that it was unreasonable that he should pay more than his selling price. But the court stated that it was reasonable because 30 cents was the royalty paid by regular licensees, and it would be unreasonable that the infringer would be in a better commercial position than regular licensees, and also it was not relevant whether for the application of Article 94, it is not relevant whether there is intentional infringement or unintentional infringement. So even a good faith infringer who has to pay reasonable compensation can end up having to pay more than his costs, his selling price, etc. All right. How can I get my face off the screen? Do you manage that, Michaela, or not? It vanishes from itself. So this is what the court in The Hague said in this matter. Then we have another infringement case which was from Germany, which went all the way up to the EU Court of Justice. This was a case of Summer Daisies Lemon Symphony, a plant variety right of the firm Hansen. Hansen had come across this infringement already it's quite old case actually. The infringements cases, the judgment of the European Court of Justice is 2016, but the infringement had already occurred in 2002. The first, it was a long period in which this infringement had occurred from 2002 until 2009. This company Grunewald, the defendant in this case, had sold more than 1.5 million infringing plants of their Summer Daisy Alexander, which Hansen believed to be an infringement of his own variety, Lemon Symphony. He first tried to prove this infringement in summary injunctive proceedings, but failed in 2 instances because he was not able to prove that the plants were infringing. And then he went to the court on the basis of proceedings on the merits, so not protective or injunctive proceedings, but proceedings regarding the merits of the case, in which the court could decide on the infringement and also on the damages. And in this principal case, the court awarded an amount of 60,000 euros for 1.5 million infringing plants, which, if you make the calculation, boils down to a little over 4 cents per plant. And Hansen was not satisfied with that judgment, because he said, well, I've had much more costs. I have also had all sorts of other damage, like loss of value of the plant variety right. I have I've lost interest, all sorts of other damages, and I've also, in fact, first tried to put a stop to this infringement in the injunctive proceedings, which didn't work, and now in the principal proceedings I was put in the right. So if I get only 60,000 euros for this long time infringement, I am not fully compensated. And for this, he claimed that he should have been awarded much more, and the German court asked questions from the European Court of Justice, preliminary questions of law on how they should handle this, and how a reasonable compensation should be applied. Therefore, I have this second poll. Michele, maybe you can pull up the poll again, because I had much too much text on screen.
Yes, I would only ask the participant, please just see very well what is the claim 1 and 2. So 1, additional compensation of 50% to cover for the other damage, and 2, compensation of the cost for the injunction proceeding, which he had been unsuccessful, because the question is only going to be the second, so you will not have them. I will open up the poll now, which you should be able to see. And as a reminder, please be reminded that claim 1 is additional compensation of 50% to cover for his other damage, and claim 2 is compensation of the costs for the injunction proceedings in which he had been unsuccessful. Thank you for the answers that are coming in.
I decided to ask this quick poll simply to get a feeling for what you deem that is reasonable, and I will then, if we have done the poll, I will tell you a little bit more about how the Court of Justice views this kind of matter.
Yes, so now 39% of participants answered, right, and these are the results.
Yeah, there is a majority here who thinks that it is reasonable, and that is obviously also what most right holders think, is that they should be able, that it is reasonable, that they should be able to claim other damage. But the correct answer, which the CJEU gave, is for the minority of 9%, they should not be able to claim either 1 or 2, so nor 1 nor 2. And the reason is the Court of Justice said that Article 94, paragraph 1, cannot serve as a basis for a flat rate infringer supplement for the restitution of profits and gains made by the infringer. The concept of reasonable compensation has, says the Court of Justice, covers the fee that would normally be payable for licensed production. So in the same way as in the Speck and Heiko Rose case that I just had the first poll about. In addition to that fee, the court said it includes, that is, includes all damage that is closely connected to the failure to pay, which may include payment of default interest, but nothing more. And then the court said that the further damage on the basis of Article 94, paragraph 2, must be determined on the basis of specific matters to be forwarded in that regard by the holder. And it could be a lump sum if not quantifiable, but it is not possible to claim a lump sum markup of 50% in excess of or in addition to the actual damage which can be proven. And the court said that it is not contrary to that provision if the costs incurred in an unsuccessful interlocutory application are left out of account in the determination of damage. So therefore, Hansson could also not claim back the costs that he had incurred for the failed injunctive actions that he tried to undertake in the first place, initially before these proceedings on the merit. So this shows that it is sometimes very difficult and unattractive for right holders to get into lengthy proceedings. And this is probably also a provision that needs to be reviewed. Luckily, now we also have the Enforcement Directive, which enables, which gives right holders better possibilities to recover the costs of enforcing their rights. So you really have to make a clear distinction between damages on the one side, which is loss of profit and costs, and on the other hand, legal costs, the costs which you incur to get a proper determination of your rights, a proper infringement order, and or recovery of damages. These are the slides which provide the answers of the CJEU in the Hansen-Grunewald case. Then, as I already said, sometimes when you encounter an infringement in the market, you must act very quickly. And in such cases where you see that your plants are being sold at the auction or are being propagated in preparation of marketing these plants, then you need very quick relief, and therefore we usually basically all legal systems provide for the possibility to obtain temporary injunctions where you can get a judicial order to stop the infringement in a few weeks' time. And that is something quite different than proceedings on the merits, which you also saw in the Hansson case, where you had the two types of proceedings, where the courts take more time to get to a decision on whether a plant variety right has been infringed, and on a proportionate and reasonable amount of damages. And principal proceedings on the merits usually take have a lead time through the courts of between 1 and several years. Then there is also, thanks to the Enforcement Directive, there should be in all legal, in all national laws, and this 1019E CCP is the provision number in the Dutch Code of Civil Procedure, but similar provisions should be available under all national laws in the EU, and that is an ex parte order. That is an order which can be asked by a right holder without involving a defendant. So this is a unilateral action before the court where the defendant is not heard, and this is available in situations where there is not even enough time so not even a time to wait for a few weeks to get this to get an injunction, where usually an injunction proceedings is a normal proceeding, but very quick, where if the putative infringer, so to speak, may be heard and may explain to the court why he thinks it's not infringing, or why certain provisions certain measures should not be given. And the ex parte orders are for situations where it is reasonable that a quick measure is given on the spot without hearing the defendant. Now, I have another poll regarding this issue, I thought. Yeah, this is the poll. So, what do you think in terms of rules on lead time of infringement actions? Are there European rules regarding such actions? And the first option is there that there is a maximum time for proceedings, for all sorts of proceedings, including proceedings on the merit or injunctive proceedings? There is a maximum lead time for proceedings on the merit, but not for injunctions proceedings and ex parte actions. And the third option that you can choose is whether is that there are no such rules at EU level, and that it is left for the national member states themselves to make those rules. I'll allow you some time to make your choices. I should mention that the second option is slightly different than the answer that I had in mind. So
yeah, I made a mistake, unfortunately.
That's no problem, but we will correct it on the spot. So the second option is there is a maximum for proceedings on the merit, but not for injunctive actions and ex parte actions. How far are we? Yeah, the majority is right again here. There are no such rules at EU level. So, and that's actually a pity, because sometimes it can take very, very long. And that is why the injunctive actions are sometimes very important to be available, because they can, ensure that there is an immediate stop to an infringement, so that the right holder does not incur any further damage. Because if he would have to wait for sometimes for years until a case is being adjudicated in a national before the national courts, then that would be very disruptive for the business of a right holder. So that's why these injunctive proceedings are always an option to. I have to do away with this reminder. Are a good way to get relief on the spot and stop the infringement from causing more damages. Then there are some. How am I on time, Michele? Actually, I have the feeling that I'm speaking. I'm not going to finish all of what I would like to say, but at least we have covered quite a bit. How much more time do I have?
I'm not going to stress you on time here. So how much time you have, we can keep on going, and if participants cannot follow until the end of the presentation, we still have the recording, so we can send it back.
All right, that's fine. Thank you. How do you deal with licensees who are, that's the first question, how do you deal with licensees who are not paying their royalties? so who are paying late or are not paying at all. This happens a lot, unfortunately, in the horticultural world, and also in regard to other crops. There you have a problem, of course, to determine whether the sales being made by licensees who are in default, whether these sales are authorized or unauthorized, because that's a big issue, of course. And because if they would be unauthorized, they would be infringing the rights. But if they have a license, the sales would not be unauthorized. And the way to deal with that is obviously you have to demand payment. That's for a start always. But if payment doesn't follow, usually the license agreement, and even if it doesn't include any express provisions, you should be, as a right holder, be able to terminate the license because the licensee is in default. And from the moment onwards that the license has been terminated, and usually non-payment is a very serious breach of an agreement, then the production by that terminated licensee becomes unauthorized, and then sales or importations or whatever become infringing. And that is, of course, obviously, therefore, always an important step to take when there is late or non-payment. And other forms of non-compliance is basically, should be treated in the same way. There is an important provision in the EU regulation, paragraph 27, paragraph 2, which says that the holder may invoke the rights conferred by the community plant variety right against a person enjoying the right of exploitation who contravenes any of the conditions or limitations attached to his exploitation right pursuant to paragraph 1. So this Article 27 says that if you contravene, if you breach the license or limitations while you have a licensee, this is also a matter for which the holder may invoke his rights. So under EU, under licenses of EU rights, this Article 27 brings along that a termination of the license is not strictly necessary, but under many other national laws or other laws, a provision like Article 27 doesn't exist, and there the termination of the license may be essential in order to be able to take action. That's something, it's a remark that I want to take. I will now get to the anti-piracy regulation. I realized with a shock, more or less, that the latest version is already dating back to 2013. The anti-piracy regulation is a regulation which, as I already said, relates to the stopping of all sorts of counterfeit goods, and usually that is counterfeited trademarked goods or designs, but it also can be used for counterfeit plant varieties, which is a bit of a strange concept, of course, but because a plant is always a copy of a real and original plant. So the concept of counterfeit in relation to plants is really a legal concept, where you have a plant which has been produced without a license. But it is good that when this is the case, that you can also take action on the basis of the anti-piracy regulation, which was created to prevent that counterfeit goods will enter free circulation of goods traded in the EU, and which has been created on the basis of the belief that stopping counterfeit goods at the outer border of the Union is easier than in case they have already entered the common market, and where a right holder who wishes to stop infringement would be necessitated to take action in individual countries. That's the primary objective also of this regulation. It has a limited scope. Not everything that is produced without a license is counterfeit. It does not deal with parallel imports, so goods which are plants which are parallel imported are not under the umbrella of this regulation, and also goods produced in excess of quantities agreed between producer and right holder cannot be acted against under this regulation. So if you have a license outside the EU who is producing more cuttings or more plants and importing them at European auctions, but he is a licensee, then also this kind of importation cannot be halted on the basis of the regulation. And the same, which is a bit of a pity, applies to transit situations where, for example, plants produced in South America are being transported through the airport of Schiphol in order to be sold and delivered in a country outside the EU, for example, Russia. Also, transit situations are not covered by the regulation. What you can do as a right holder if you are being confronted with regular importations from countries where you have no right, but there is production of your plants, is that you file an application for action. This can be done union-wide, and it can be done on a country-per-country basis. And the filing of an application for action under the regulation is open to the right holder, but also to licensees. Obviously, a union application requires an EU-wide right, so there you must have a CPVO title. Such an application may be filed before or after actual suspension. You have to file an application, and the application should include information on the variety in the case of plants. It should also include information on the provenance of counterfeit goods, so that relates to details of shipments, country of origin, travel data, suspected arrival data. It's all sorts of information that you can provide about means of transportation. And then you should also provide technical details regarding differences between fakes and originals. This is obviously a provision that relates to counterfeit clothing or similar products or mobile phones, but it's difficult to do that in respect of plants. But there you can provide details on the kind of packaging, for example, on the fact that the counterfeit plants are being imported without or with a different variety denomination, that sort of stuff. That's the kind of data you should provide to the customs authorities to help them to identify shipments which they should suspend. This is some rules on applications and decisions. It's not so interesting, and I'll skip it in the interest of time. This is, let's say, the core provision of the regulation. So if goods are being offered for importation in a certain country, and there is an application for a granted application for action, if then upon the importation the customs authorities are alerted on the basis of the details provided with the application by the right holder. The goods are being suspended for release into the trade. Then the customs informs the right holder that there is a shipment which is believed to be counterfeit. The customs provide the holder with information on the quantity and the nature of the goods, and you can also request names and addresses of addressee, of shipper, of declarant holder, and the right holder also gets information on the geographical origin of the goods. The right holder then will be given an opportunity to go to the warehouse, the customs warehouse, to inspect the shipment and determine whether indeed it should be deemed counterfeit, and he can also take samples. Yeah, so that is all a very effective way of dealing. And let me check, where am I? Yeah, and if then the right holder confirms that the goods are infringing, and the declarant or the shipper or the owner of the goods does not react, does not object to the suspension of release, does not take the position, no, these goods are not counterfeit, and these plants have been produced under a valid license, then the customs authorities can proceed to the simplified destruction, and that is being done without any formal determination concerning infringement. So there is no court that is involved. There is no court decision that the plants are indeed determined to be infringing. It can simply be done on the basis of the fact that there is an application, that the holder has indicated that the goods are indeed believed to be counterfeit, and that there is no objection from the holder of the goods or the addressee. There are a few conditions. Obviously, the one is that the right holder is convinced that it is infringing, and that he communicates that to the customs authority. He must also consent to the destruction of the goods, and the holder of the suspended goods gives his consent for the destruction or remains silent. In case there will be an objection, then proceedings have to follow for the determination of the infringement claim. It all happens very quickly. If there is a suspension of release, the holder should advise the customs within 10 days that basically this is a matter of infringing goods, and they should be destroyed. As you will see on the slide, it also says it can be 3 days, and the 3 days is an even shorter term that applies in case there are perishable goods are offered, and this is always the case when we are talking about plant varieties. So for plant varieties, the term is always 3 days, and for other goods, the term is 10 days. Yeah, this is a bit more about the simplified destruction. Then there is an important article, important provision in the regulation, which is Article 2021, which sets forth that information obtained through customs action should may be used only for well-defined purposes, which are listed below. Proceedings to determine whether there is infringement may be used in connection with criminal investigation related to the infringement, It may be used to seek compensation from the infringer or other persons, or to make an agreement that the goods be destroyed. And in regard to this provision, I thought it was good to also have a little quick poll. And for that, I should give a little bit better introduction. Let's assume shipment of roses is being held up because it is believed by customs to be infringing, but it appears that the roses are coming from an authorized licensee, and that it is a matter of plants that are being produced in excess of a license. As we have seen, that is a situation that is not covered by the anti-piracy regulation, but still you have the information, and you are, because the anti-piracy regulation doesn't apply, you cannot proceed to simplified destruction. But then, of course, because they are in excess, they are produced in excess of the license, and there is a breach of the license, you would like to take that licensee who is breaching the license to court. Are you allowed to use that information for such purpose, or are you not? And the answers, possible two answers, are either yes, because the anti-piracy regulation allows such use for information for proceedings to determine whether an IP right has been infringed, or is the answer no, because the regulation only allows for use of such information for the purposes of well-defined actions which follow a customs action. So we get the little poll on screen again, I hope, yes. You are all thinking about this in silence. What do you think follows from Article 21 of the regulation? So where are we, Michele? Are you already in the position to produce results?
40% answered.
Okay, that's fine, I think.
Okay, then we have 42% yes and 58% no.
A close call. And I have a very intriguing answer. I think I should say that there are good arguments for both sides. This is an issue which is not clear from the regulation, but it is something to be aware of. Under an older version of the regulation, it was clear that you could not use such information obtained from a customs action for other purposes. But given the scope of uses that are being mentioned in Article 21, I think there are some good arguments to argue that you can use such information for follow-up proceedings if these proceedings are being if the purpose of such proceedings is to get a determination of infringement and or compensation or whatever. So this is simply was a question to make you aware that sometimes it's not always clear what even a European regulation can say, and this is something you need to take legal advice on under your own jurisdiction. Well, then there are some other things under regulation which I would like to skip. There is one other case which was in the Netherlands a few years ago. In this case about a celeriac variety, there that concerned the burden of proof of an alleged infringement when a right holder requests leave for an evidence seizure, and also the scope of the right when it comes to the act of offering a variety for sale. In this case, there were two varieties of two different breeders, and these varieties, celeriac varieties, were reaching the end of the duration. And there was a trader, or it was basically it was a grower. Novisem was a grower, and they were intending to start producing these varieties as soon as the duration of the plant variety right had ended. And in order to know how much they should be planting, they were already seeking orders to be delivered from the moment that the plant variety right was no longer valid. The maximum duration would have lapsed. So they were going around in various countries in Europe, making disclosing their intentions to start producing these varieties, to even offer prices. But they clearly said we can only deliver these varieties when the plant variety right no longer applies. This was a very interesting case and an interesting issue. The right holders, the two right holders who were represented by the Anti-Infringement Bureau, lost in two instances because the courts in factual instances said that this is not an infringing offering, and the appeal court in Den Bosch ruled that the distribution of price lists or arousing interest by a seller is by itself not an activity that is necessarily infringing. There must be additional circumstances to qualify such activities as making an offer, the appeal court said, and the right holders were not satisfied with that judgment, and they went to the Supreme Court of Appeal, and in order to make it a bit more dynamic, I have the fifth and last quick poll on this question. This is the poll. So the question is, if a grower makes an offer under the condition of delivery after the expiry of the right, should that be deemed offering for sale? Would you answer no, because an infringing offer presupposes that the actual act of delivering takes place while there is a valid right? Or would you say yes, because making an offer in respect of material that enjoys protection also encompasses an offer that is being made under certain conditions? This is the two choices that you can make. Obviously, I have told you about the Interplant case, where the court said that there was no compensation of damages if the plants had not reached the market. And this is an example, basically, of how sometimes you must read the law very carefully, and the answer to the question whether the act is an excluded act or not, often depends on the actual wording of the law. Obviously, the Dutch participants, I don't know how many Dutch participants there are, they may know the answer to the question already. I hope I made the question clear enough. Give you some more time. That's good. Well, the majority has given the same answer as our Supreme Court. The Supreme Court ruled indeed that making an offer in respect of material that enjoys protection by a PVR also encompasses an offer that is being made under the condition that the delivery is not yet possible, which is basically good news for right holders, of course, because this effectively means, to a certain extent, this effectively means that the duration is a little bit longer, or at least that if your right is about to expire, you cannot be confronted with a competitor who has been able to make preparations for a market for his own products. So sometimes the courts are very I see that you can even see my dog on the background now, who is hoping that I will take him out, so I will not take it too long anymore. So this was the answer of the Supreme Court, and I'm indeed reaching the end of my presentation. And I think I have used far more time than you may have expected. We will see in a minute how many participants we have left. My conclusions are the following. The first is there are plenty of means for enforcement of PVRs in countries that have implemented the enforcement tools prescribed by the Enforcement Directive. Provisions regarding compensation of damages are sometimes should be written with two O's, of course, too strict to offer an effective degree of protection, which is certainly true at EU level. One remark that I somehow skipped, I think, is the following, that funny enough, the Enforcement Directive, which was made in the year 2000, and which included directions to the member states to improve the protection in their national laws, the Enforcement Directive is directed to the member states. But as we have seen to a limited extent, the EU directive, the EU regulation on the protection of plant varieties lacks all sorts of provisions and is not so clear. And I think if you would measure it against the Enforcement Directive, that we could say that the EU itself has not implemented the directive, and it's also a directive directed to the member states and not to the EU itself. But there is a strange divergence, I think, and there is a review already for a long time. It has not reached the top of the agenda of the EU lawmaker, but there should be a review of the regulation, and my recommendation is that they should also have another good look at the Enforcement Directive and include a number of rules which then also will be for the benefit of EU right holders. So that is the background of this last remark, which is certainly true at EU level. And also, and the third remark, that the enforcement rules in the regulation are in need of renewal and improvement. So this was what I liked to bring to you today. I hope you found it interesting, and I think and I wish to thank you for your attention, and I hope there will be a number of interesting questions which we will see from now on, I think.
Thank you very much, Tjeerd, for this very interesting presentation. I am opening up now the question and answer part of our webinar. So to all participants, please feel free to ask all the questions you'd like. I have anticipated you, so to say, because the most frequently asked question that we always receive at every webinar is, when will we receive today's slide and recording? I told you before, but some participants just joined us a little bit early, so That's going to happen tomorrow morning or afternoon at the latest. We have another webinar tomorrow morning coming up, so therefore might be that you receive it in the afternoon, but still you're going to get them. Don't worry about that. And the second question, it's this time directed to you, not to me anymore. And such question is the seizure possible for transit plans? So we talked about a little bit transit plans, the example of a cargo stopping in Schiphol but wanting to reach Russia. Would that a seizure possible in that case?
No, not anymore. For transit, it's not into circulation here in the EU. So basically it is, yeah, it's believed not to be infringing. That is with one but. If the plants are being trademarked, so if they are traveling under a trademark and you have a trademark in the EU and also in the country of destination, then it may be possible to seize these plants, but not on account of an infringement of the plant variety right, but on account of an infringement of the trademark. So that shows that sometimes it creates a benefit if you have trademarks protected. If you have a trademark plan for offering your plants, and if you have registrations.
Just one further perhaps question. Does the infringement of a trademark have to be in the European Union? So in this case, for example, in the Netherlands, or in the country of arrival, so in Russia, for example?
Yeah, basically, that's why I also said that you that you need a trademark in the country of destination. The basis is that there is a threatened infringement in the country of destination too, and then it's possible to seize. That is a novelty in the EU trademark regulation, which I hope we should also get in the EU plant variety rights regulation. Similar, but that's not yet the case at the moment.
Thank you very much. We have a third question from Robert, who's asking which techniques or methods were used to prove the infringement in court. Is this DNA?
Yeah, everything that that you can apply to show that that a plant is the same or has been essentially derived, which can be DNA, but can also be a description of the original plant, so to speak, and the infringing plant from a growing trial. So that's possible, but I have been involved in various court cases where proof on the basis of DNA tests was accepted by the courts. Yeah. I hope this is a satisfactory answer. It's a very short answer.
Yeah, Robert, thank you.
Then of course you have proof by witnesses. Obviously, sometimes you also need to prove sales or offerings at an auction, and for that sort of facts, you can use basically witness proof or proof while using a bailiff who makes an official description of certain offerings. There is a wide variety of techniques and methods which you can present in court. Yeah. Any other questions?
Thanks for the answer. At the moment, we don't have any other question, but just for your information, it's 12:14 and 27 participants stayed out of 34 which means that your presentation was actually very interesting.
Okay.
And yes, it's like 95%. And but it could be that some of you might have questions and they just didn't pop out in this session today. So I would kindly ask, perhaps if you'd like, when you will receive the follow-up email, you can also answer and perhaps write us further questions that you might have, and we'll do our best to come back to you as soon as possible. Also through the helpline, we can always help like that.
Happy to do so.
Catherine.
Oh, I just wanted
to nice to see you
also. I did not yet want to interfere, so please go ahead. I just thought I'd come back on stage to.
No, it's nice to see you. Please, the floor is yours.
Okay, I wanted to thank you, both of you, for the cooperation with the IP Helpdesk. This is a great opportunity for us, and I hope for you too. And it would be great for us to repeat that. So many thanks for your kind cooperation and all the services and the nice contact we had. And shared, of course, you again shared all your knowledge, and it's great to have such an expert with a lot of experience. Sorry, not all the knowledge now. Yeah, thank you very much for your time.
Pleasure to do it.
It is always also time. Yeah, you have to invest some time. So many thanks. That was the CIOPORA part, which I wanted to emphasize on.
Okay, thank you.
Thank you very much. Thank you both, and I'm very eager to repeat this experience again as soon as possible. And also, we're going to come up with further webinars regarding plant variety. You can check them out on our website. I'm going to be very happy to host you all participants once again. I wish you all a lovely day. Thank you for being with us today. And yeah, see you very soon as possible.
Okay.
Thank you very much. Have a good day, everybody.
Bye-bye.
Goodbye.
Have a nice day.